All right, future barristers, let's talk. One of the biggest things you're going to face in court, and for sure on your bar exams, is the rule against hearsay. Think of it like a giant brick wall built to keep unreliable evidence out. But here's the thing, for every wall, there are gates, and today we're giving you the keys to those gates. These are the common law exceptions to the hearsay rule. Look, mastering these isn't just about passing a test, it's about getting absolutely crucial evidence in front of a judge for your client. Right? Let's get into it.
So here's our game plan. First, we're going to come face-to-face with the hearsay wall itself, understand what it is. Then we'll start unlocking the gates one by one. We've got the spontaneity gate, the state of mind gate, some really important gates for witnesses who can't be there, and finally, a few procedural and statutory keys that you've just got to have in your toolkit.
Okay, so let's start with the big obstacle. You have to think of the hearsay rule as this fundamental principle of exclusion. It is the default setting in any common law courtroom. The door is closed unless you have a key. And there it is, in black and white. So what does this actually mean? It means if someone says something outside of the courtroom, you can't just get in the witness box and repeat it to prove that what they said was true. And why not? Well, because that original statement wasn't made under oath. And more importantly, the person who actually said it can't be cross-examined. The court just sees it as fundamentally untrustworthy. The real kicker here is the purpose you're using it for. If you just want to prove that the words were spoken, fine. But the second you try to use it to prove the content of those words is true, bam, you hit the wall. And this is the million-dollar question, isn't it? I mean, what if your witness heard the victim's last words, or a bystander yelled out a license plate number as a car sped away? This is evidence that could literally make or break your entire case. So how do you get it in? You find a gate, you find an exception, you use your keys. So let's grab our first key, and it's a big one, res gesta. Now, don't get hung up on the Latin. It just means things done. This exception is all about statements that are so tangled up in an event, so completely spontaneous, that the law figures they've got to be reliable. The thinking is pretty simple, you know? If you blurt something out in the heat of the moment, you probably haven't had a chance to cook up a lie. What's really fascinating here is how this whole idea has changed over time. The old school approach, from cases like Carlyle, was super strict. It demanded that the statement had to be made at almost the exact same time as the event. It was like a rigid stopwatch test. But today, the modern approach is way more flexible. The courts are less worried about the exact number of seconds and more focused on whether the speaker had any real opportunity for concoction or reflection. Was it spontaneous? That's the real question now. In this case, this is just a brilliant illustration of that modern test. In Ross v. Hamilton, you had a plaintiff who was semi-conscious after being hit by a car. About 5 minutes later, he mentioned seeing a little green man. Now, he wasn't hallucinating. He was talking about the little green walk now signal at the crosswalk. And the court let it in as part of the res gesta. Why? Because even after 5 minutes, given his condition, the chance of him fabricating that story was basically zero. It was a spontaneous thought directly connected to the accident. All right, our next key opens up a completely different kind of evidence. What a person was actually thinking or feeling at a specific moment. These statements aren't so much about an event happening outside, but what's going on inside someone's head. And this exception is so incredibly useful in practice. You can use a person's own words to prove they were in pain after an accident. Or, say in a wrongful arrest case, what a police officer said at the time can be used to show they had a reasonable belief from making that arrest. But the classic example, the one you have to know for your exams, is Walton v. the Queen. In that case, the murder victim had told several people she was on her way to meet the accused. Her statement of her intention was allowed in as evidence, which then allowed the jury to infer that she probably did go to meet him. It is such a powerful tool. Okay, so what happens when your key witness is no longer with us, when they're deceased? The common law gets it. It understands that sometimes, for justice to be done, we need to hear from people who can't speak for themselves anymore. This next set of keys is designed for exactly that tragic situation. At common law, there are really 3 main gates for statements made by someone who has passed away. You've got statements made against their own interest, statements they made as part of a legal duty, and then the really dramatic one, dying declarations. For our purposes, let's just focus on the 2 you are absolutely going to run into, statements against interest and dying declarations. Now, the absolute crucial point for this one is that the statement has to be against the person's financial interest, their pecuniary interest. A perfect example is someone admitting they owe a debt. The law's logic is that people generally don't lie to make themselves poorer, so that gives the statement a ring of truth. And the person had to know at the time they said it that it was against their own interest. And then you have the most cinematic exception of them all. A dying declaration is only admissible in one type of case: homicide. And the test for it is incredibly high. The person making the statement has to have a settled, hopeless expectation of death. They have to be completely convinced they are about to die, with absolutely no hope of pulling through. The idea is that the sheer solemnity of that moment acts as a substitute for the oath, compelling them to tell the truth. All right, finally, let's look at a couple of keys that aren't really about the statement itself, but more about the rules of the game in court, procedure, and how modern statutes have come in and reshaped this whole common law world. Now, this is a neat little procedural trick every barrister needs to have up their sleeve. It's also a bit of a gamble. If you formally call for your opponent to produce a document during the trial, a document you haven't seen, and they actually produce it, they can turn around and force you to tender it as evidence. And if you do, boom, everything in it becomes evidence of the facts, totally bypassing the hearsay rule. It's a powerful move, but you have to use it with caution. Okay, pay attention because this is a vital distinction, especially for anyone looking at a career in criminal law. It's the move from the old fresh complaint doctrine to the modern preliminary complaint. The old common law rule in sexual assault cases was super restrictive. A victim's complaint had to be made at the very first reasonable opportunity. And even then, it could only be used to back up their credibility, not to prove the assault happened. Now, statutes have mostly replaced this with the preliminary complaint, which can be admitted no matter when it was made, and this is the game changer, it can be used as actual evidence of the facts. A truly massive shift in the law. So let's pull all this together. What do you need to remember? First, the hearsay rule is the wall, but your job as a barrister is to know where the gates are. Second, spontaneity is your golden key for res gesta. Third, a person's words can be a direct window into their state of mind. Fourth, the law has created pathways to hear critical evidence from those who've passed on. And finally, never forget that this stuff isn't set in stone. Procedure and statutes are always changing these old rules. And that brings me to a final thought for you to take away into your studies and, hopefully, your future careers. As big, comprehensive evidence acts become more and more dominant, they're constantly changing, codifying, or just flat out abolishing these old common law rules. So the question for you is, which of these ancient keys do you think will stand the test of time? And which ones will become nothing more than historical relics? Knowing the answer to that, well, that's going to be the mark of a truly great advocate.